A huge round of applause for our speaker, Advocate Arjun K Perikal.
Good afternoon, members. I'm extremely happy to introduce the speaker for the sixth technical session of the conference, Advocate Arjun K Perikal. Arjun is a Bachelor of Science in Economics and Statistics and a law graduate. He is a partner of Shardul Amarchand Mangaldas and is into dispute resolution, corporate restructuring, insolvency and bankruptcy code, and real estate practices. He has advised several public sector as well as private sector clients in across cross-border and domestic schemes of arrangements and amalgamation. He has drafted documentations for some of the large investments in real estate sector in India. Totally, he brings in 19 years of professional experience addressing a diverse spectrum of legal matters. Independent director and chairman of Audit Committee of LIC of India. With this brief introduction, I present before you Arjun K Perikal. Thank you. So, all the best.
Good afternoon, everybody. I can't hear anybody. Good afternoon. Yeah. So I think it was a fantastic meal for everybody, and I need to wake you all up now. I know the subject is a little dry as such, but it's interesting as ever. It's an evolving subject, and it's a jurisprudence that we all are trying to see how it's growing. It all got introduced in 2016. The Insolvency and Bankruptcy Code was introduced in India. And largely, like everything that we follow is British. This is also, by large, it's the verbatim spirit and letter, a follow-up of the Insolvency and Bankruptcy Code of United Kingdom in 1986. So the whole genesis of our insolvency code is also that of the British Insolvency Code. So while there we see a lot of steps that have already been taken before the British insolvency proceedings, we are still in a nascent stage, and we are trying to grapple with a lot of changes, and there are quite a lot of amendments that have come through in this subject in the last 2 years, 2-3 years. But that said, our judiciary system has been quite robust, and we have seen quite a lot of changes in the way the courts have approached. There have been, based on practical experiences, courts have coming up with new proposition as to how to tackle with situation. And while I understand most of you as chartered accountants professionals would have been associated with some insolvency proceedings in some form or another, Uh, Primarily, first, uh, what is this whole insolvency proceedings about? I know it might be a little repetitive for a few of you who have also already looked into this subject, but just for the benefit of everybody to just bring people onto speed on the subject, I'm just trying to dwell on this. So insolvency proceedings was introduced by in India in 2016 to address the situation of grappling economics companies to liquidate their assets, or when they're in distress, to recover monies in a faster manner and with maximum realization of the asset value. So that's the primary objective of this code, to maximize realization or to ensure that the companies continue to function in their for what it was envisaged for, without loss of job or a loss to creditors. Because ultimately, in a company, the liabilities of a creditor is promoter is limited to the contribution that he has made. And if some company which has got a capital of say 10 crores and they have a liability because of working capital which has gone to 50 crores, and things go wrong, the company can be able to, any bank or any lender can recover only 10 crores worth of assets, because that's all the assets that is there. So in such a scenario, the insolvency proceedings come in place, where if the court feels that a company which has got a liability over 1 crore rupees gets admitted under the insolvency proceedings, in such a company, a resolution professional will be appointed, and the resolution professional will take charge of the company, will take over the board of directors. The current board of directors will get suspended, and the resolution professional will take charge of that company. So thereafter, the resolution professional becomes the management of the company, which will be an interim resolution professional, and he will call for meetings of creditors, and the creditors will form a committee of creditors and confirm a resolution professional who shall be the director of the company to manage the affairs and dispose the assets, or ensure that the company is resolved in a manner that it can continue functioning by seeing where the leakages and financial leakages were done, or if there's any money that can be set off against any person's, individual's wrongdoing. So those things can be stopped, and immediately some action can be taken. Now the current code provides for a moratorium period of 2 years soon after an application for insolvency has been admitted. And thereafter, the liquidator will seek for valuation of these assets, and they'll do two valuations. One is a fair value and then a liquidation value, and call for bids from potential investors who will take over the investment in the company and run the company profitably. In this process, if there's any losses that are there in the company, any liabilities to any unsecured creditors, instead of unsecured creditor getting nothing, he will get some portion of it. Similarly, creditors also will see that what is the dependency on these unsecured creditors or suppliers of this company, so that they get the required amount of capital from them, business continuity from them, so that they can continue doing business in the company. So once these liquidation proceedings have initiated, this is the normal course of liquidation. Now, what we are now trying to evaluate and trying to exploring is the next step. Not that every company is run on an individual basis, but it's all a group of companies. Now, if you ask me what is a group of companies, there's no definition called a group of companies in either Companies Act or Insolvency Act. We have at best something called an associate company, and group companies is not a defined term as such. But every company, we say group of companies, and then if one company goes into liquidation, would all the companies in the group go into liquidation? Anybody? No. So it's not that if one company goes into liquidation, all companies have to be drawn into liquidation, because the essence of a company is each entity is a separate legal entity by itself. So if one company goes into liquidation, that does not mean another company goes into liquidation. But that said, the jurisprudence internationally, which I will address a little also. Yeah. So is if one company goes into liquidation, why should the group company be also held responsible? Now, if the group company has also lent money, like typical situation will be a parent subsidiary situation, where if a parent goes into liquidation, would a subsidiary also have to come into liquidation? It will always be a question mark. But there have been jurisprudences on that which says that just because a parent goes into liquidation, a subsidiary need not come into liquidation, but the investment of the parent in the subsidiary can be drawn into liquidation. Now, what is the theory behind all these things? That's basically in what circumstances the group companies have dependency is explained here. First is in an operational scenario, and second is in a financial scenario. In operational scenario, you will have group companies which are related to each other in the form of like a parent will be developing some product, the subsidiary will be manufacturing some logistics for that company, and another subsidiary will be handling with all the retail outlets for that entity. Now, all these together are required for this functioning of this company. It's not like if one company goes into liquidation, the other company cannot survive, and the company, if the parent is one of the companies in the group is taken for liquidation, the other companies are required to conduct the business. So it's all interlinked to each other. So in such a scenario, it's called as operational dependency, where there's reliance on raw materials and inputs or service. Second is financial dependency, because of if you're dependent on other companies for your funding, like typical will be your corporate guarantees that are given from the parent to subsidiary, and subsidiary sometimes gives a corporate guarantee to another company. Or if you have given a corporate guarantee to suppose one of your vendors has given you a corporate guarantee, and then thereafter the vendor goes into liquidation, what happens to you as a company? So it will all be dependent on that group company's guarantee also. So in such scenarios, it's considered as financial dependency on each other. So in these scenarios, where there is a clear dependency on each other, then it is considered as a single economic entity. But for that to be triggered in India, we all have to file separate petitions for each companies under liquidation. It's not like if one parent company is under liquidation, automatically you can draw the subsidiary also into the liquidation process. You have to all file separate petitions. So this step of so I'll explain to you a little in detail what are these rules for procedural coordination. Now, for this group insolvency, what we are considering right now is in what way we have to, what are the rules that are being discussed by the draft committee, so that in future when this group insolvency comes into play, how the law will be looked at, and how transactions in the past will be looked at is what I will now look at addressing. Now, if there is something called as rules relating to procedural coordination, these are rules that are targeted for coordination of procedures but do not disregard separate legal personality of different group companies. If you are dependent on, like if you take this company for liquidation as a group company, you're not looking at doing a resolution of each of the entities together, but you will procedurally do a resolution plan of each of the entities, like trying to fix insolvency commencement date as one date, and try to move before the court as one instance, try and get one resolution professional to take charge of these companies. These are called as procedural coordination in insolvency proceedings. So where you're coordinating or syncing every group company which are to be taken for resolution to be resolved at one go, so that it's not like one company goes forward and another company is still not even a resolution professional is appointed. Then it can't be like, it's not a race of one of the group companies taken up for liquidation and other companies still being decided whether to be taken for liquidation or not. Because all these liquidation processes have to be done together. Otherwise, the economic value of realization or revival of this company will be lost in this process. So one way of looking at resolving is through procedural coordination. So in this, you also will have the ability to propose a strategy for coordinated insolvency proceedings and the coordinated use and realization of disposal of assets of different group companies, which will still be approved by each company stakeholders separately. So in this way, we can have a procedural coordination. Then the second rule for coordination is enabling substantive consolidation. Here, it's not like you, where if you're looking at, say, example, a company which is dealing with some particular product which is dependent on the raw material from another group company itself, and the logistics of supplying is held by another company. So all these are held together, and each of these companies are required. You can't bring in a third-party supplier at any instance. In those kind of scenario, you look at taking this under a substantive consolidation approach. So in substantive consolidation of estates of all group companies or some group companies, you can also look at partial consolidation approach, where if you feel it's not like all companies are required, but only some of the companies are required in this process. So again, this procedure is on consolidated process is still not uniform across all countries. Some countries have this, some countries look at more on a procedural consolidation and not look at providing for substantial consolidation. Then there's rules relating to perverse behavior in corporate groups. Now, what is perverse behavior in corporate groups is one of the biggest sins of most corporates are, like, they think that a corporate is like a proprietary concern, and they keep transferring funds from one company to another, and they keep making payments to friends and relatives ahead of time. They don't have proper documentations. It's not like some leeway is taken in some scenarios, or if they find that somebody is a friend and they want to make a payment ahead of other people. Now, these are all considered as perverse behaviors. And also, if you have a scenario where within the corporate group you know that your company is not functioning well currently, and you are in the verge of getting into liquidation proceedings at some point in time, Just before that happens, 2 months, 3 months before, you start disposing of all your assets to another group company, or you start disposing of some stocks to another person that you know that you can have a back-to-back arrangement with them. These kind of scenarios are called as perverse behavior in corporate groups, and there are rules that is envisaged for setting aside such perverse behavior in corporate transactions. In these things, there's an extension of liability, extending liability of a group company to other group entities, usually to parent entity, particularly where the subsidiary has wrongfully traded and the parent company has not mitigated the same, or longer look-backs or stricter burdens of proof regarding avoidance actions. Is like if you take a, there's something called as principles of blind eye knowledge. It's like closing one eye and letting somebody continue to do what he is not supposed to do. So these act of blind eye knowledge kind of, I'll put my blind eye and say that I was looking through and I did not see anything is not an answer. So courts will hold that it is considered as a perverse action which requires considering every entity that has taken benefit from such perverse actions to be drawn in under the corporate group insolvency proceedings. So these are three basic rules under which group insolvencies are being considered in India. Now, this is followed from the unit trial model of enterprise group insolvency. The United Nations model on enterprise and group insolvency had come up in 2019 with this model of enterprise and a group to consider two or more groups that are interconnected by control and significant ownership. Now, the coordination for purpose of this, they also believe in coordination and cooperation, which is basically a coordination on hearings, like I told, the procedural aspects that I explained earlier, or information sharing is again a procedural rule, or coordination carrying out different activities including administration such as marketing, and then appointment of same insolvency representative in different insolvency proceedings, agreement for cooperation and coordination, which is again an article. So all these are part of the unit trials models. All the three rules that I earlier quoted are from the unit trial model that we are considering, the legislation is considering to be part of the group insolvency papers that is proposed. Now, in these, how do we plan these proceedings? The planning that are involved in group insolvency for the whole or part of the enterprise pertains to the main proceedings of an enterprise group member that is necessary and integral part of the group insolvency solution. So like I said, if every company or in the group which is interdependent on each other, so such groups can be drawn into it, the insolvency proceedings. And these proceedings must involve the participation of group members and appointment of group representative. The model law also envisages the development of multiple planning proceedings for different parts of the enterprise group. And the insolvency solution is one which involves development of proposals for the resolution or liquidation of enterprise group members with a view to preserve and enhance the value as a whole. So these are the broader points under which the unit trial model has been framed. And again, that is on planning and proceedings. The second portion, the third portion is on treatment of enterprise of group in group insolvency. So the treatment of enterprise groups in insolvency recommends features of legal framework dealing with domestic group insolvency as well as international group insolvency. In case of international group insolvency, the guide recommends access to courts. I think that's on next. Access to courts and recognition of foreign insolvency proceedings. Now, access to courts for purpose of recognition of foreign insolvency proceedings means access to not just the courts in India, but also if there are group companies which have entities outside India, so such group companies transactions should also be drawn into the group company insolvency proceedings, for which if the countries are part of the UNITROL protocol, then they will also be able to make an application simultaneously in all jurisdictions and bring such companies into the UNITROL model of insolvency. And which will also allow us to, if an insolvency proceeding is initiated against one company in a foreign jurisdiction, the outcome of that order in a foreign jurisdiction will also apply for insolvency proceedings in India. So this is one of the key terms that have been proposed by in the UNITROL model, which is being considered as well. Next, cooperation involving insolvency representatives. Now, in this we will look at cooperation through resolution professional. Is suppose if you have group companies and each group company has separate resolution professional, then imagine right now just with one resolution professional handling an affairs would have become a challenge. Now each person is taking his own stand, taking his own process and taking his own time, and if the resolution processes are in different jurisdiction, then each group will be going through a resolution process at a different pace. This will all not be in the best interest of the group, because the group will be, the company will be able to resolve and come out successfully in a resolution plan only if the entire group is taken up together and resolved for a better economic gain for everybody involved in the process. So this involves cooperation, for which it might be also that we'll have a common resolution professional, or there'll be one lead resolution professional and other multiple supporting resolution professionals to ensure that the group insolvency proceedings are conducted in a cogent manner. Now, again on cross-border insolvency agreements, the guide recommends that insolvency law should allow insolvency representative and other parties of interest to enter into such agreements to facilitate coordination of the management of different proceedings. So which means it also says don't be stringent on these aspects as to who should be the resolution professional and how the resolution professional should act. It should be left open for the committee of creditors of all the groups together who come together and facilitate a platform where they can appoint one resolution professional or the resolution professional as they may feel and as appropriate. And all these things can be binding through way of a commercial contract between resolution professionals on the bylaws on that. So they plan to set up a model bylaws on this, which will be which companies can follow on the cross-border insolvency as well. Now the same principle has been also been recommended by the World Bank for effective insolvency and creditors debtor regimes in 2021. The World Bank principles for effective insolvency recommends the following international domestic group insolvency. One is through access to court and recognition of proceedings, which is more a procedural coordination. Like I earlier said, if you were to access the court in different jurisdictions, then try and build programs where all the companies in of the group which are situated in different jurisdictions are brought under one fold and under one jurisdiction, where one jurisdiction NCLT and the resolution professional can take lead in running the resolution. This is called procedural coordination. Again, cooperation involving courts. This is post-commencement if they need any resolution plan and approval so that the funding requirements are met. So on these things, cooperation through courts. Cooperation involving resolution, insolvency representatives, so that the ultimate aim of every resolution professional, if is appointed for different companies, he acts in the best interest of the company, of the group, and not look at the best interest of only that particular company in which he is appointed. So that becomes important. Now, the Indian courts have also supported on these aspects, which I'll deal with at later. But this is the broader jurisprudence under which the law is being framed, and this is also what is recommended by the World Bank for effective resolution of groups. They also recommend appointment of insolvency representatives to avoid actions and cross-border insolvency agreements. Now, the group insolvency in the European Union, you must be wondering, why am I taking you through the insolvency proceedings of other nations? Because we are looking at group companies, and as we start looking at multinational companies today, and if a multinational company goes into liquidation, it's not about just one company in one country jurisdiction that laws will apply. It's the laws of multiple jurisdictions that will apply in such scenarios. And as every practicing professional involved in a corporate, be it a lawyer or be it a chartered accountant, your work that you've done in the past will be seen through not just by the resolution professional or accountants who will be appointed in the process of in one jurisdiction, but across jurisdictions if it's multinational companies, and the laws of those countries under which they are formed, they will also start looking into the company's affairs in the past. Now, even in the European Union, there recommends cooperation and communication between insolvency representatives appointed to different group companies and different courts administering insolvency proceedings, and cooperation and coordination between insolvency representatives. So, in the European Union, it also speaks of right of access to an insolvency representative appointed in an insolvency proceeding relating to one group company to ask for a hearing, stay, or opening of a group coordination proceedings, which means if one company is admitted, he can ask for a stay of another company's proceedings if it is, he can prove that that other company is also involved in this company's business activities. And also further, the group coordination proceedings involve appointment of group coordinator. They have envisaged something called as group coordinator. You can have somebody called a group coordinator who will coordinate between all group companies, and such a thing is recognized principle under the European law. Now, similarly coming to the United States, unlike the European Union, which more looks on procedural coordination, looks on substantive consolidation, which means the United States looks at including deemed and partial consolidation mechanisms are used widely when creditors dealt with entities as a single economic unit, or the affairs of the debtors are so entangled that consolidation would benefit all creditors. Separating assets would be prohibitive or hurt for all creditors. Just a classic example will be if you take one big multinational company's one asset which is manufacturing some electronic equipment in United States, but the complete manufacturing unit is situated in, say, China, but the biggest market for that product is, say, in India. Now, if one of the companies goes into liquidation, it's not like that company can survive without the other company's support. So it is, you have to take everybody together, and the creditor's interest as a group has to be looked at, and all the companies together have to be drawn in for liquidation is what the United States model recommends. Now, in the US also, the procedural coordination is witnessed in the form of joint administration of proceedings. There are also specific provision allowing equitable coordination of claims of parent company where it has violated its fiduciary duty, resulting in injuries to the subsidiary creditors or other shareholders. Now, while I explained to you the jurisprudence under UNICTROL, how group insolvency is being considered under European Union and the United States, now I'll come to the insolvency code in India. Now, under the insolvency code, under section 62 and 3 of the Insolvency and Bankruptcy Code, where group companies are corporate guarantors to each other, their insolvency proceedings will be dealt with by the same bench of the National Company Law Tribunal. Now, while the Indian IBC does not recognize group insolvency as a full concept, there are specific provisions in the Act which enables such insolvency proceedings if you have different jurisdictions. If the companies are situated in different jurisdictions, then in which jurisdiction should be the insolvency proceeding should be taken up is provided under section 62 and 3. Then section 18F and 36, like I earlier told, if the shares of a subsidiary, if there's a parent and multiple subsidiaries are there, and assuming for a moment the parent company is taken up for liquidation or is admitted for liquidation, the subsidiary has nothing to do, and subsidiary has other joint venture partners involved in it. Stakes of other interest investors are involved in it. And the subsidiary is able to sustain by itself on its own. Then in such a scenario, will the subsidiary also be drawn into insolvency proceedings? The answer to that is no. For two things, like I earlier said, each entity is separate by itself, and you can't draw up a subsidiary just because the parent goes under liquidation. Then what happens to the value of investments made by parent in the subsidiary? The investment of every parent company in a subsidiary will be in the form of shares. So only the shares that has been invested in that company will be valued and taken up as a liquidation asset, which will be sold to somebody else to take charge of that particular shares as such. And the company, which is the subsidiary, will not be taken for insolvency proceedings. This will also ensure that the subsidiary's economic value is not lost, and it's also generally the moment an insolvency proceedings is admitted, the economic value of such companies will drastically drop. No lender will be interested in continuing business with such a company, and there will be huge challenges in the financial payouts. To avoid these stalemates in these scenarios, the code provides for sections 18F and 36, where shares held by companies are also to form part of an estate to be dealt by the resolution professional. Sometimes it may be used to enable some level of consolidation in affairs, particularly with solvent group companies. Now, again in section 43, subclause 4 and 46, it provides for longer look-back periods. Now, what is this longer look-back periods? Is basically periods for related party avoidance transaction to deal with perverse behavior. Like I earlier mentioned, just because you know that, or just you know that your company is not doing well, and you start siphoning off funds of the company to another company, or you start selling the assets of the company to another company, knowing fully well that this company might go into liquidation, and the promoters will, if they have some economic benefit from such a transaction, and if such a transaction clearly looks as a blind-eyed transaction, where if market value of a property is say 100 rupees, and you know that even under liquidation value it will not be less than 100 rupees, and they sell it at 50 rupees or 20 rupees, then it clearly meets a challenge as to whether such a transaction is true transaction or it's a perverse transaction. And if there is a perverse transaction, those kind of perverse transactions can be undone by the courts under section 43. Then lastly, this is another provision which has not been explored by most companies or most creditors, is provision under the Companies Act. Under Companies Act, section 230 and 230 provides for scheme. This is a scheme of compromise or arrangement Normally, we always think that a company scheme means scheme of amalgamation or demerger. No, it is not only a scheme of amalgamation or demerger. You can also have a scheme for restructuring of capital of a company. You can also have a scheme where creditors come together and decide to form an association amongst them, make a resolution plan to take over the company. So these are things that are possible under Section 230. This is an area that has not been explored as much as it should have been, where if it's a scheme under 230, in fact, if a promoter is genuinely clear that it is he has not done anything wrong and it was because of some economic challenges that the company has gone into liquidation. If a company goes under gets admitted under IBC, the promoter cannot participate in the transaction. The promoter will be ousted from the management, where it becomes important that the continuity of promoter is important for better functioning of this company. A scheme under Section 230 can also be considered, because what happens under Section 230, unlike an IBC proceedings where it says that the promoter cannot participate in the company which has gone into liquidation, in Section 230 there's no such restriction on promoters. So this is actually beneficial where promoter knows that there are some challenges in running the company, and it is better to formulate a scheme where that scheme can be proposed between creditors, and take your creditors into confidence and propose a scheme, and that scheme can be considered under Companies Act under Section 230. So these are the options that are currently available under the Indian Companies Act for group insolvency. Now, while these are the current options, what is that is being looked at in the country? There was a working committee formed in 2019, headed under the chairmanship of Mr. UK Sinha. He was the former chairman of SEBI, to submit a report recommending complete framework to facilitate insolvency, resolution and liquidation of corporate debtors in a group. So we are still trying to formulate a policy on this, and that policy is being deliberated at this point in time. And the broad outlines of this policy is to create an enabling framework with only communication, cooperation and information sharing amongst group companies, so that common expression of interest is there between each of the group companies. You can look at the committee is also proposing common resolution plans, single application process for commencement of CRP amongst group, and then designation of a single adjudicating authority for a group. These are things that, following the unilateral model and the European Union model, it's a combination of these things, and also our drafting committee has also come up with some beautifully drafting provisions here. And they also have looked at a framework agreement to govern coordination proceedings, delineating estimated costs, distribution of costs, appointment of group coordinators, and they're also proposing extension of a 90-day framework in an event of group insolvency proceedings. So they are also proposing rules against perverse behavior, which is a subordination of claims of related party in limited cases of fraud, or extension of liability to other entities which are related or part of the same group. Exiting provisions for governance of certain transactions are sufficient, and contribution orders to solvent group companies. Now, if one company is in the group is taken into liquidation, so the court can consider to pass an order on of the group company which has taken economic benefit of this entity under a resolution process, deors the creditors. So that way you can draw their orders for a group company to make contributions for liquidation. There was also a report by CBIRC on group insolvency in December, under which they also proposed considering the unilateral model on enterprise group insolvency and procedural coordination mechanisms to be available under the group insolvency framework. And they have also created a broad and inclusive definition of group to be adopted on the basis of control and significant ownership. So they have also expanded the scope of group to mean not just to include basis control. If a company has some promoters have control on the group and they have significant ownership, directly or indirectly, all these are considered as part of a group entity. So they've also recommended that if there's a solvent company within the group, such company should not be drawn into this group insolvency. There are deliberations on that aspect also. It's not like if it is not dependent on other group company and it's just because it's solvent, it cannot be drawn into the group insolvency proceedings if there is no element of fraud coming out there. And they have also strongly recommended the joint applications for initiating of CRP before NCLT with territorial jurisdictions, common resolution professionals, like I've earlier spoken. Now, let's look at the judicial trends on this. Now, some of the key judgments in this regard is the first primarily the State Bank of India versus Videocon case, which has been the landmark case on the subject of 2019, which envisaged substantial consolidation in most popular form of group insolvency proceedings. And they proposed two steps process. One is carrying out an analysis on the following factors, which is common control. So the judgment of in the State Bank of India versus Videocon, they dealt on this subject and said how a company can be considered as forming part of a group company. That if they have common control, common directors, common assets, or common liabilities, interdependence, interlacing of finance, pooling of resources, coexistence for survival, interlink or intertwining of accounts, interlooping of debts, singleness of economic units, or common financial creditors, and common group corporate debtors. So the judgment is laid down these following aspects to check if a company forms part of a group. Further, preliminarily assessing whether consolidation yields benefits to stakeholders is also to be looked at, because if consolidating and taking the companies under group insolvency, if it is likely to give better yield, then such companies should also be considered as part of the group insolvency proceedings, is what the courts have held. But for that to happen, each of the companies in the group currently, as the law stands, should be, an application should be filed against such a company, and such a company should have been a resolution plan has to be admitted. The debtor should be admitted for a resolution plan. They also proposed procedural coordination, which is also less common. This is laid down in the matters of where joint application has been recognized in the matter of Mamta versus AMB Infrabuild. Joint hearings and designation of a single court has been dealt in the matter of Edelweiss ARC versus Sachet Infrastructure. Then appointment of a single resolution professional has been dealt in the matter of Radico Ketan, where they said that if there are multiple companies in the same group, then a single resolution professional can be appointed. This has been a recognized principle pursuant to the Radico Ketan versus BT and FC Private Limited. And coordination to have a single resolution plan. This was held in the matter of Punjab Bank versus KSK Mahanadi Power Company Limited.
Then again, to work on principles of cooperation and coordination has been recognized in the matter of Ajit Kumar, a resolution professional of K Lifestyle Industries versus Manasi Vadekar in 2021. However, even where procedural coordination is not sought or ordered expressly, there are some cases where in practice COC choose to appoint the same resolution professional and conduct joint meetings for different debtors. In other cases, additionally, there are cases where subordination orders have been made and separate legal personalities have been disregarded in order to hold parent entity liable, at least in the interim, for debts of their subsidiaries, in the case of Bikaram. Now, what are the challenges that is being faced in this group insolvency process? Is challenges arising in practice, lack of nuanced application of group insolvency rules. Currently, courts apply substantive consolidation to groups without considering the underlying nature of business enough. Where there are different types of business, courts should permit deemed consolidation where the claims are consolidated but the entities are still allowed to emerge as separate. This will enhance competition and attract more resolution plan, which means if they can identify the group as separate entities within a group, and if a resolution plan is proposed in a manner that each unit can be taken up in a manner, but with a coordination between each of the companies, then the economic realization under the liquidation process will be far higher, which is what is lacking right now as to coordination amongst group insolvencies. Then there's issues relating to timelines. In case of substantive consolidation, key challenges are faced because valuation reports or claim and CRP costs are for different dates. And since the insolvency commencement date for different corporate debtors is different, this makes it difficult for common value or consolidated claims and allocation of cost. Then again, in cross-border issues, where it's a multinational company, because we are not still formed a group insolvency act, and we are not completely following the unilateral model still, and without any cross-border treaties on this. There may be difficulties in coordination with foreign representatives of taking control of foreign assets in the absence of cross-border insolvency framework. This will leave the debtors with foreign liabilities without foreign assets outside the insolvency proceedings currently. There are also difficulties in application of substantive consolidation because for substantive consolidation, where courts requires managing the expectations of heterogeneous creditors is proving difficult because each creditor is acting independently. Now, coming to the balancing acts that has been done under IBC, what are the balancing acts that have been created to ensure that insolvency proceedings are done in a manner that it will help every stakeholder to realize the maximum benefit? So has been dealt with separately in the insolvency code. The IBC balances the interest of all stakeholders by creation of a statutory platform for insolvency resolution before liquidation, where different stakeholders have given different roles, responsibilities under IBC to achieve a balance in the interest of all stakeholders. It entitles financial and operational creditors, including workmen, employees, government as operational creditors, as well as corporate debtors to initiate corporate insolvency resolution process against a corporate enterprise. So this is one more balancing act. It's not like one
only a creditor can initiate an insolvency proceedings. There are various people who can initiate this process. When it comes to granting authority to make commercial decision to either resolve or move forward in liquidation, that right has been given to all financial creditors, whether secured or unsecured, while keeping operational creditors out of decision-making process in this regard. However, to counterbalance the same, a safeguard of minimum payment of liquidation value to operation creditors has been built into the statute, which says only if there's a minimum value of liability, such a operation creditor can have a say in the liquidation or in the insolvency proceedings of a company. Further, in instances where the insolvency resolution was to fail, the company was to go into liquidation, the balance is sought to be achieved by deprioritizing the government dues, bringing unsecured financial creditors in rest with unsecured operational creditors. So that way there is again a balancing. It's not like the government dues will only take priority over operational creditors or other unsecured creditors. It will be all set on the same parameter there. The whole object of insolvency code is to balance the interest of all stakeholders through an ecosystem of mutual rights, responsibilities, and role allocated amongst different stakeholders under the IBC. This balance is not achieved by imposing an obligation either on the resolution applicant or the COC to achieve the same by way of a commercial proposal by a resolution plan beyond the scope of section 30 of the Insolvency Act Code. Now, this principle has been considered in the matter of JP Kensington Boulevard Apartments case. This is actually quite a landmark judgment as such in this whole balancing of interest. So here the Supreme Court in 2021 set aside the order of NCLT and carrying out certain modifications to the resolution plan that was already approved, where our firm had also involved in that, and to represent ICICI Bank, who was one of the dissenting creditors in this matter, where the question that was raised, what is the rights of a dissenting creditor in such a resolution plan? Does it mean every creditor has to sync together and agree to the same plan? No. The courts have held now that if one of the creditors is not agreeable to the resolution plan, he can stay outside the resolution plan and try and exercise his rights independently by the collateral that he has against his company. So in such a scenario, the creditor that is the dissenting creditor will not have a right to get the asset in specie, but he will only be able to get the value of his claim in monetary basis, not in kind, or the collateral that he has got is the best at which he can exercise. The power and jurisdiction of NCLT while dealing with the resolution plan approved by the Committee of Creditors was decided if the NCLT exercises its power to modify the resolution plan, then it is within its jurisdiction to do so. In concerns with the previous judgment, Supreme Court clarified that NCLT, while hearing an application for approval of resolution plan, cannot interfere with the commercial wisdom exercised by the COC, which means if the Committee of Creditors have decided on a particular resolution plan to be done in a particular manner, the court should not interfere in this resolution plan, and it should only look at the parameters have been followed and not say that you should not do this, you should not do this, cannot be intervened by the courts in this process or the tribunal in this matter. This is what the Supreme Court has laid down. And it is also laid down that if there is any challenge in the parameters not being met, then such a resolution plan should be sent back for consideration by the Committee of Creditors, and the court should not come up with its own resolution plan as to how it should be done. Rather, send it back with saying that what are the parameters under which it is not followed, and it needs to be considered on that. And it's also decided on treatment of dissenting financial creditor has been dealt with under section 30 and 53 of the Insolvency Code, where it will not, the dissenting secured creditor will not be forced to take an equity stake in the company or take some portion of asset of the company. It is free for them to choose that what should be the liquidation. If they don't come forward and be part of the resolution plan, they'll only be getting monetary consideration as part of the resolution process. And the resolution dissenting creditor cannot be forced to remain attached to the corporate debtor of continuing to give him the financial loan. So such force cannot be done in the process. And also it's very clear right now that the courts have held, if there is a resolution plan and if there's not a person is not a party to such a resolution plan, you cannot extinguish the security interest of a third party or a third party secured creditor without assigning any value to the same. So if there's any third party claim or third party contracts are there, unless that party comes forward as part of a resolution plan, you can't change the commercial nature or commercial understanding between the parties. And a party who's not, a creditor is not party to the resolution process cannot be forced to agree on any different settlement proposal other than what he already owns. And as part of resolution plan, you can't, if some charge has been created, the charge cannot be undone without the consent of such charge holder also. Now, coming to treatment of minority shareholders of corporate debtors. Now, in this case, the courts have held that when it comes to minority shareholders, the minority shareholder will be given a due share, and it is up to the committee of creditors to decide how much is the amount that is available for disbursement amongst the minority shareholders. The minority shareholders can only come and challenge the amount paid to the minority creditors only if there is the value of the corporate debtor is more than liquidation value, and the creditors are not sharing that liquidation value amongst the minority shareholders. Failing which, minority shareholder per se cannot come and challenge liquidation proceedings or an insolvency process, saying that their interests are not being taken care of. Now, again, when it comes to, again, contracts, suppose some person has signed a contract with a company which goes into liquidation. The fear is, one is the amount that the company owes to that vendor becomes an operational debt, and it becomes as an operational creditor. If there is some surplus, only then he will be entitled to receive. But if that vendor is required to continue to do business with the company or during the interim period of resolution plan, the commercial terms will not be altered. Whatever is the commercial term will be continued to be honored, and the committee of creditors or anybody cannot force upon any of the supplier to corporate debtor to change the commercial terms. And also, like I earlier told, these resolution plan can also extend to assets of subsidiary if the subsidiary's assets are intervened or interlinked to the assets of the parent, or the parent is interlinked or intertwined with that of the subsidiary. Now again, coming to another key aspect that we all keep encountering is this home buyers issue. Now if these home buyers are initiating a resolution plan, The courts have now consistently held that it should be not that every asset of one particular builder will be taken up for insolvency proceedings. It's limited to project. So in all these home buyers cases, it is limited to the projects in which an apartment purchase is entered into. And there also the courts have held there can't be a haircut on the apartment owner's contribution. It will be only to the extent of his contribution, whatever his entitlement in the that he's booked for will be honored. But payments to other vendors will undergo changes in this process, and which will be subject to resolution plan. And this, with this section 25 of the IBC provides for minorities within class are bound by decisions of majority. Now, if there is, they've considered that an apartment purchaser as a separate class by himself. Now, if there are, while an apartment purchaser will be considered as an operational creditor, he will not be forced to take the resolution plan of the other operational creditors. The apartment purchases as a group is considered as a class, and if all the apartment purchases as a group vote in favor of a resolution plan, so such will prevail on every apartment owner in the group. And courts have also further held that if one of them decide that they don't want to take the apartment, but they want this money back from this company under liquidation, then he can't ask for any higher, better value. He'll be considered as an operational creditor itself. So these ways, there have been there's also the case of Binani Industries, where they've held that without any reason, you can't discriminate two sets of creditors in a similar situated position. So courts have consistently now trying to balance every stakeholder in insolvency proceedings. There is jurisprudence that is being developed towards group insolvency, and as a practicing professional, we need to be cautious of the fact that going forward, every act or every audit or every matters that we have dealt with, if we have turned blind eye to a particular subject, so those blind eye subjects will be picked up in insolvency proceedings and looked through, and it will be undone, and then aspersions will be cast on everybody. So care and caution should be exercised by every professional in this whole process. So I'm happy to take any questions if you have anything.
The forum is open for questions now. If anyone is having anything, can be asked. We have time for 5 questions only.
Yes. Well, I guess there's not much questions at this point.
Okay, well, once they start
Thanks, everybody.
practicing, probably they will have
Yeah,
more
you can always
questions.
reach out.
I think we have
Yeah.
one question there.
In case the company has filed the insolvency petition, what will be the status of the landlord who has rented the building? And the furniture available which is there has been mortgaged to the banker. So what does it, how does the, it takes years together since the liquidator appoint, things have happened. What will be the status and what will be the remedy for the landlord?
Yeah, it's case specific, but yeah, the landlord can make an application to NCLT for disposal of the asset and ask for vacation of the premises. I understand where you're coming from. The rent which was payable for the period when since the resolution profession gets appointed till the time of liquidation will be amount that needs to be paid by the resolution profession from the resolution process to the landlord. So the assets will remain in the premises till it's disposed. So there's no yeah. If the assets are removed, the economic value of the company will also be lost. So, yeah. Well, thanks everybody. Thanks for your patient hearing. Thank you.
Thank you so much for a wonderful session post that sumptuous lunch that we have had. You definitely kept us all alive throughout the session, sir. I now request CA Manjunatha Hallur, Secretary, Bangalore branch of SIRC of ICI, to kindly present a memento to Advocate Arjun K as our token of appreciation and gratitude. CA Manjunatha S. Hallur, Secretary, Bangalore branch of SIRC of ICI. Ladies and gentlemen, a huge round of applause to Advocate Arjun K Perikal for taking us through the wonderful session on group insolvency and balancing interest of stakeholders under the process of IBC.